Another issue that I wanted to talk about arose out of the June board meeting, in which there was discussion by the board concerning what are the boundaries of the board and school officials with respect to limiting student readings, whether it be textbook readings or library readings. And as I'll go over the case law with you, the distinction is often drawn between curriculum-based text and, for example, library text, or sometimes referred to as optional text. The seminal case is a 1982 Supreme Court case. It's entitled Board of Education, Island Trees Union Free School District versus Pico. And the case's facts are really worthwhile just reviewing, because I think you'll see some connection to some of the issues and discussions here. What this case involved were parents who had been active in a politically conservative organization, who at a conference had received a list of books that they found objectionable. There were 11 on the list, and 9 of them were actually in their main high school's library. The board gave unofficial direction to have staff remove the books. They had contacted them. I guess there was no sunshine law at that where they were there. And they said that they wanted the removed books to be sent to each and every one of them so they could read them. The board issued a press release indicating that the books they found were objectionable and didn't want students to be reading them and saw them as a moral danger. The board appointed later a book review committee that found 5 of the books should have been retained, 2 should be removed from the book libraries, and 2 of them they couldn't agree upon, and on 1 of them they couldn't take a position. Despite the report of that committee, the board decided that out of the 11 they should remove 9 of them. They were sued and they lost, and it went all the way to the Supreme Court. So let's just talk about some of the legal principles that are present in the Supreme Court's analysis. It understands that the Constitution limits a government to in its control over the curriculum and the classroom, although it does recognize that the board certainly has the right to be concerned about the types of texts that are being issued. There's no question that that oversight, as well as with its own staff, is a real one, but it's a question of how far do you go. The court noted that the case that they were looking at didn't involve textbooks, but it involved library books. So it immediately drew the distinction between textbooks and library books. And the court noted that library books are different because they involve optional reading. They are not ones that are required, for example, for course credit. The court noted that a student's right to freedom of expression, including reading, cannot be abridged just because someone might be fearful or dislike the materials, or they might be uncomfortable with them. In fact, the court wrote, I think quite compellingly, for us here and for our students, that access, quote, to free speech and ideas prepares students to become participants in a pluralistic society. This is especially important with respect to the library, where students should be free to inquire, study, evaluate, and gain new maturity. For the court, then, the student learns from the library that it is a place of ideas, and school officials cannot just shut down ideas because they're uncomfortable with them. The court went on to add that the First Amendment does not tolerate laws that cast a pall of orthodoxy over the classroom. The Constitution does not permit the official suppression of ideas. Thus, it concluded the board was wrong to remove the books just because it didn't like the ideas that were contained within it. It recognized that there may be from time to time sound pedagogical reasons to prescribe certain books if it's found that the work was what they call pervasively vulgar or lacked educational suitability, and the court recognized that there's often a tension between those two because they may go together, which would then require one to determine if something's educationally suitable. Would that then supersede the so-called vulgar elements in it? And so that analysis would go forward. The textbook analysis is treated differently from library book analysis. The question of textbook analysis, because usually it's involving the required courses, is often linked to what becomes a concept later under a Supreme Court case called Hazel School District versus Kuhlmeyer, in which court says that any decision with respect to textbooks should be reasonably related to a legitimate pedagogical purpose and concern. So they will often take into account age, maturity of students, and so on. But books, no matter what, just can't be banned because one doesn't like the content of them or experience them as unpleasant, especially with respect to the ideas that are involved. In 1998, in the Ninth Circuit, there was a case, and this is kind of interesting because I think you'll begin to see the complexity of the matters. There's a case called Montero versus Tempe Union High School District, in which the plaintiff sued the school board because they believe that books by Mark Twain and William Faulkner should be removed because they contained racially derogatory terms. The court said no. Just because some of the contents may be experienced as vulgar or uncomfortable is not grounds for removing them from the class or from the library, because it would involve the suppression of ideas and the student's ability, and this is the key point, to receive information and to come to grips as they grow older with such controversial ideas as they grow into adulthood. An interesting case in 2006 occurred in Miami-Dade, in which the Miami-Dade School Board voted to remove a book about Cuba just because the board felt it did not adequately discuss the oppressive conditions in Cuba. In a lengthy opinion, the federal court ordered the reinstatement, and it applied the PICO analysis that I was just going over with you. The court noted there are really better ways to tailor the concerns than book banning, even where there may be sensitive themes such as sexuality and vulgarity. And as you can see then, a court's going to look into these issues carefully. And we had this experience, and I'd just like to mention for a minute, where a passage was read that contained a graphic scene in the book Dreaming in Cuban. As a result of that, I went back and I read the book. And it's an extraordinary book, actually. And one of the things that the book is about, which you can then realize that there has educational suitability to it, is it's a book about the splitting of families brought on by the communist revolution in Cuba. It's highly critical of that event. And it shows through an extended family not only what happened in people who went out of the country, but the continuing family tensions internally over this event. Let me just read a passage which would have been helpful for people to realize just how that one passage, sexual passage, and I'll give it to you, go over that in just a moment, is helpful in any analysis. Her son was almost 13 when the revolution triumphed. Those first years were difficult, not because of the hardships of the rationing that Celia knew were necessary to redistribute the country's wealth, but because Celia and Javier, which is her son, had to mute their enthusiasm for El Líder, which was Castro. Her husband would not tolerate praise of the revolution in his home. So here you would have an important debate that would go on in a classroom, what's happening internally to a family as a result of these terrible events. The sexual passage, I understand why it was read and why it was found to be upsetting and uncomfortable, but when you read it, there's a context to it. And it actually involved a husband and wife and the growing abusiveness of the husband in connection with the wife. And those also are issues, especially with teenagers, that have some value to teach respect in relationships and certainly what happens when power relationships tilt in a certain direction. Those issues would be discussed in any challenge that would be brought to a court. They would look at certain issues: what constitutes educational suitability, what constitutes pervasive vulgarity, is it a library book? They're going to be a lot more strict on library issues because of its optional nature and because the court sees the library almost as a sacred place for a kid to learn, be left alone, read, and so on. And I recall that questions arose by board members, very, very good questions that in fact were linked to case law, such as, well, could we have a certain area that's put aside of books, and that, like a reserve section perhaps, or a section where nobody could touch those without parental involvement or say so whether the kid can take those books out. And there are cases that say that's possibly an option. The problem with those situations is, one, how are you going to get those books there? Who is going to be doing the decision to place them there? You can't just arbitrarily just come in and say, I want them there. There would have to be some committee review and analysis that would say, well, these 10 are pervasively vulgar, or they're such a concern for students that here's a situation where mom and dad should have the final say as to whether they are taken out of the library. You also have the risk that most people don't consider, that a shrewd kid says, I won't take it out. I'll just stay in the library near the check area and I'll read it right there. I mean, there's all kinds of ways that that can be circumvented. Certainly with respect to textbooks, because it's curricular, the standard of review is more, does it have a legitimate pedagogical purpose to it? And so a board then can scrutinize it a little differently. Obviously, that's what we'll have as part of any committee process, and that's the whole issue here, as to have it go through reviews, as we saw in PICO when the committee looked at books at the request of the board. So where would that leave us? In my view, we're always best not to head down the path of isolating books or banning them, certainly. In my view, there should be support given for greater parental involvement in the child's education and monitoring what the child can do. How can that be done? Well, I had an idea that one possibility would be the ability of a parent to know if his or her daughter took a book out. They then can say, I want to know, sit with you on it, and be able to track through our system. And I thought, well, do we have the technology for that? I went to the superintendent and said, from what I can see, you have an option or an opportunity to make sure that parents are actively involved in the kids' education. You can go online and go to the school, and you can get some sort of input in which the student and parent says, you know, I understand you took this book out. Let's sit down. I want to see it. So that would allow that parent certainly to be actively involved. I did learn from Dr. Patton that actually she and staff were already at work on that technological project. And so maybe it's best that I pause here and ask her to describe for all of you what the initiative, and then obviously if board members have thoughts on it. I realize it's attorney discussions, but it's an important issue that people should speak up about, or we can talk about it next time. But Dr. Patton, maybe you can describe that technological piece that I was just mentioning.